Hello, everyone, and welcome to Constitutional Criminal Procedure, Criminal Law 1. Today's topic of discussion is the jury trial. So just as a quick review of what we discussed last time, generally speaking, when it comes to the admissibility of evidence, courts are bound by both the Constitution and the respective rules of evidence, whether it's at the federal or the state level. Well, in terms of eyewitness identifications, they are notoriously unreliable. Methods can include lineups, show-ups, and photographic arrays. We talked about the strengths and weaknesses of each. And we've noted that due process and limited counsel rights do apply when it comes to lineups and show-ups. Now, we always think that scientific evidence is the hallmark, is the gold standard, but scientific evidence can be very problematic. For instance, serology, hair specimens, arson analysis, etc. So before, we used to have the Fry standard, about half the states, and now we have the Daubert standard in about the remaining half of the states. A couple things to keep in mind are DNA. DNA can never point to one person, right? We can limit it down to about one in, or seven in a billion, basically. And then fingerprints, obviously these are chance impressions, you don't leave them every time. And contrary to popular belief, you can have the same fingerprint, just generally speaking, that's not the same full set of fingerprints. And then polygraphs, as we've discussed before, they're notoriously unreliable, only admissible in one court in the United States. And oddly enough, you have to take a polygraph and pass it in order to work for federal law enforcement, even though we know that it is pretty much junk science. So let's talk about the constitutional right to a jury. The constitutional right to a jury is found in 3 places in the Constitution. So we have Article 3, Section 2, the trial of all crimes shall be by jury, and trial shall be held in the state where said crimes have been committed. Constitutional Amendment number 6, in all criminal prosecutions, the accused shall enjoy the right to a speedy and public trial by an impartial jury of the state and district wherein the crime shall have been committed. And the Constitutional Amendment number 14, nor shall any state deprive any person of life, liberty, or property without due process of law. Each of these speaks to the requirement that you be given a jury trial during criminal proceedings. Now we'll discuss jury trials versus bench trials and when this doesn't necessarily always apply, but generally speaking, this is kind of our starting point. So let's jump back to the criminal justice revolution. All right, 1968, we have Duncan v. Louisiana. Now, this is our kind of limitations on the right to a jury trial. Duncan v. Louisiana said the jury trial is only a fundamental right in, quote, all serious criminal cases. Okay. So this was expounded on a couple of years later in Batson versus City of North Las Vegas, in which the court held the right does not extend to petty or other offenses, right? So how do we make the distinction of whether something is a serious criminal case or a petty crime or offense? Well, Batson tells us that a petty crime is any offense carrying 6 months or less imprisonment. As such, petty crimes should not be confused with misdemeanors. Right, so a misdemeanor is less than a year in jail, and a petty crime is anything that carries 6 months of imprisonment, right? So when we think about it in these terms, if you're talking 6 months, you have to have a jury trial. And if you're talking a petty crime, a misdemeanor, excuse me, I should say, you're talking a year or less. So 6 months versus a year or less. Now, the number of petty crimes or an addition of fines and lengthy terms of probation, for instance, 5 years, does not affect the analysis, right? So you might get 2 months in, or you might get 7 months in jail, and then you get slapped with a $10,000 fine and 10 years of probation. Well, the fine and the probation don't count. All we are concerned about is the actual term of imprisonment itself. So this brings us to the 12 juror requirement, right? We're all familiar with the 12 jurors, right? So this brings us to Thompson v. Utah. It's a 1898 case, which held the Sixth Amendment followed the common law, defining a jury as 12 persons, neither more or neither less. Now, this is codified in Rule 23 of the Federal Rules of Criminal Procedure. Now, the court chose a lesser standard to apply to the states under the 14th Amendment. So if we look at Williams v. Florida, it held, using social science data, that a 6-person jury is sufficient and has little impact on the outcome of the case. Right, so what we get from Williams versus Florida is you can have a jury as few as 6 people. Right? You're not guaranteed the right to 12. Again, federal level is a little bit different. You're not guaranteed the right to 12, you're guaranteed the right to 6. And again, we looked at social science data and we tried to determine whether there were significant outcome differences between 12 people and 6 people. We found out there wasn't. Now, that being said, if 6 persons are permissible, why not 5? And so this will bring you to Baloo versus Georgia, which is a 1978 case. And it gets into kind of some of the nitty gritty as to why 5 doesn't work, but 6 does. So we're talking about jury selection. Generally speaking, we've got a very interesting panel, right? So basically the requirements of the jury veneer, right? The jury veneer is the body in which the petit jury or the criminal jury panel is selected. So for the jury veneer, which is going to be obviously a lot more than 12, because we have to narrow it down to 12 or 6 depending on the jurisdiction, generally speaking, we're going to look for random selection, usually randomly generated from voter registration or DMV records. Now, this can be a very big problem in places that have large cities. So for instance, most people in the city of New York don't have a driver's license. They don't need one. They don't need a car. They have public transportation. So DMV records can be problematic. Voter registration, we know that, again, even in this last election, only about half of Americans actually voted. So there are some very big problems in terms of selecting randomly, because generally speaking, the people who will have registrations or DMV records are going to be the more engaged citizens. Now, we also have a requirement of non-discrimination. So the Equal Protection Clause applies to federal and state jury veneers. Now, some exceptions do apply, right? So you cannot serve on a jury if you're a non-citizen. You cannot serve on a jury if you're under the age of 18, and you cannot serve on a jury if you are a felon. Now, the defense may challenge discrimination under the rule of exclusion. Right, so the defendant has to show substantial underrepresentation, right? And the government must show that it did not intentionally discriminate. Instead, the government must show that the underrepresentation is due to other factors, such as racial disparities and voter registration. Right, so in other words, you can't call an all-white veneer and say, well, you know, that's just luck of the hat. That's substantial underrepresentation. unless the prosecution can prove that what they did was not intentional and it was just a reflection of how things and disparities actually work. Now, the jury veneer must also represent what's called a fair cross-section of the community. In theory, this prevents jury stacking by the state, right? So the idea is the state can't choose people who they know will vote against the defendant no matter what, right? It has to be a fair cross-section. Now, the defense may challenge the veneer for not being, quote, a fair cross-section if a distinctive group is excluded. So this has to be a large and distinctive group, right? So if the jury veneer doesn't include any African Americans, this could be a very big problem. The representation of the group is not fair and reasonable, right? And so this is where we look at voter registrations, we look at DMV registrations, et cetera, to see, did this happen by chance or did this happen intentionally? We also look to see if the underrepresentation is a result of systematic exclusion. Okay? So this must have occurred for a long period, not just the single trial. Right? So you have to be able to show that in various other cases, the prosecution did the same thing in excluding certain jurors, maybe jurors of color, jurors of certain sexual orientations, what have you, from their veneers. Right? And if you can show that, then you can show that, generally speaking, there's probably systematic exclusion. Now, unlike non-discrimination, here, intent is irrelevant, right? So if you're trying to discriminate, obviously intent becomes a very big issue. When it comes to being a fair cross-section of the community, your intent in making it a fair cross-section of the community is irrelevant. Right? So you could want to be a fair section and then not turn out that way. And the fact that you wanted it to be a fair cross-section doesn't matter. Now, that being said, the prosecution must also prove there is, quote, a significant state interest in its exclusion of people from the jury veneer. Right? So this would include people like felons. Right? And the idea here is that felons might not be able to apply their law properly or what have you. So there's a significant state interest in saying that we don't want people who've already been to prison to prevent somebody else from going to prison just because they were in it. Now let's talk about jury selection, specifically the process of voir dire. So voir dire is a process of selecting the petit jury panel from the veneer, through which judges, lawyers, or both conduct questioning of prospective jurors. Now, there are significant limitations on the types of questions that implicate race or ethnicity. So I encourage you to take a look at page 500 in your textbooks as it discusses this in more detail. Now, there are two ways in which a juror may be excluded. Right, so we have peremptory challenges and challenges for cause. So peremptory challenges. If a side wants a juror excluded, they have two options. They have a challenge for cause or a peremptory challenge. Now for a peremptory challenge, you do not have to give a reason as to why you want the juror excluded. That being said, peremptory challenges are limited in number, and they may not be used in a, quote, discriminatory fashion. Right, so generally speaking, you don't have to explain why you want somebody off a jury if you're using a peremptory challenge. It just happens. However, we did get the Batson test. What Batson tells us is upon assertion by the defense, the prosecutor must provide a race-neutral reason for each of its peremptory challenges. Right, so both sides get a peremptory challenges, several. But if there is an issue in terms of the prosecution is getting rid of everyone who is Black or Hispanic, Latino, what have you, then the defense can say, you have to give me reasons why you got rid of these jurors beyond their race, right? Now, on the other hand, on the flip side, there are challenges for cause. Now, these aren't just kind of ad hoc, your gut feelings. These are based upon jurors' bias or prejudice. Okay. So generally speaking, they are unlimited, and they are also within the discretion of the judge, right? So let's say you find somebody who said, I won't under any circumstances convict this person for this crime, because I don't think it should be illegal. Well, then you can have a challenge for cause, right? Or if somebody is related to the defendant, you have a challenge for cause. So again, these are generally speaking unlimited, but you have to prove why. Now, there is an interesting implication when it comes to what's called death qualified juries, right? Because a moral opposition to the death penalty will result in exclusion for cause. So that being said, the case that you have due upon watching this video is Lockhart versus McCree, and it discusses the constitutional implications of death qualified juries. So how do jury trials begin? Well, here's how a jury trial works. You begin by presenting your opening statements. Now, these aren't arguments, so you can only make a statement as to what you expect to prove, but you can't make an argument as to what evidence means. Then there's the presentation of evidence. So this begins with the prosecution's case in chief. This is a direct examination by the prosecution, then a cross-examination by the defense. In terms of the Sixth Amendment Confrontation Clause, confrontation, yes, you have the right to confront witnesses against you, but this does not necessarily have to be face-to-face. So for instance, if we are dealing with children, right, it might be impossible for a child to testify that the person who hurt them is sitting right there in court, right? We might have them watch it via closed circuit TV or have them testify via closed circuit TV so the person can't see the alleged perpetrator. Now, generally speaking, hearsay evidence is normally excluded unless one, special circumstances are present, and two, there has been an opportunity to cross-examine the witness, right? So we think about like confrontation clause, we think about something like a witness dies before trial, right? Now the problem here is, yeah, you could bring in what they said to police or the prosecutors, but you don't get a chance to cross-examine them because they're dead. So what this allows us to do is it allows us to essentially say, okay, look, as long as the other side, the defense, has had an opportunity to cross-examine the witness, we will allow testimony in that might not otherwise be allowed, right? And the idea here is during your deposition or during whatever you did to get the witness to testify, you've basically done a full cross-examination and you've had the right to confront. At the end of the presentation of evidence, then we have the closing arguments. And now these are arguments. This is where you can just say what the evidence is and what the evidence means. And then we have jury instructions. So in criminal cases, the burden of proof must be established by the party with the burden of persuasion. And in this case, in criminal cases, it's the prosecution. Then, once the trial has the testimony has ended, jurors retire to deliberate based upon the evidence, try to convince each other of one thing or another, et cetera, et cetera. Now, generally speaking, we must allow jury deliberations to occur for a reasonable amount of time before we declare a mistrial, right? And so what happens a lot of times is we have what's called the Allen charge or the dynamite charge, right? And this is for propositions and holdouts, right? So if there is a deadlocked jury, right, the judge might order an Allen charge or a dynamite charge in which the judge says, look, if you're the only one and 11 people are voting against you, it might be worthwhile to reconsider your position. And the idea is not necessarily to force their hand, but it kind of is in a way. That being said, depending on the reason for the deadlock, the dynamite charge generally has to be given before a mistrial is declared. That being said, rendering a verdict, a jury may be polled. So you can go from juror to juror, regardless of what side you're on, and ask them how they voted. And the idea here is so that you don't see any intimidation, you don't see, well, everybody else said this, so I decided to go along with it, right? You get to make sure that people voted on their own free volition. Now, in terms of jury unanimity, this is required at the federal level, right? So 48 states require that juries be unanimous. That being said, constitutionally, we only require unanimous juries for juries of 6 persons. That being said, in Johnson v. Johnson, a 1972 case, the Supreme Court upheld a conviction based upon a 9-3 decision, right? So again, we don't require unanimity unless we have a 6-person jury. Now, if you ever want to have some fun, there's a great term called jury nullification. So jury nullification is the best way to ever get a case dismissed. Jury nullification is basically when jurors are informed that they can vehemently agree that this person is guilty, but that what they're guilty of should not be considered a crime, or under the circumstances should be forgiven. Now, this is the ultimate bad word, because if you mention jury nullification, you will get a mistrial almost instantly declared, right? Now, keep in mind, as long as you're on public property, you're out front on the sidewalk, you can hand out pamphlets about jury nullification to people coming into the courthouse. Now, that being said, once a judge catches wind of this, virtually every case that's being tried will be dismissed. Because the idea here is, yes, what they did was criminal, you have it beyond a reasonable doubt, but you don't think it should be criminal, right? So think about like possession of marijuana. Yes, it's technically criminal, but you don't think it should be criminal, so you're just going to say, we don't agree with the law, we're not going to abide by it, we're not going to follow it. So that being said, there are some related rights. The public trial. So the public trial derives from the Star Chamber. A Star Chamber was basically prosecutions that happened in secret, which is very similar to FISA court or FICA court that we see today. It applies to hearings and phases of the trial, quote, reasonably substantial to the defendant's defense against the criminal charges. In some situations, the public may be excluded. So the press may be excluded at the probable cause hearing if it's prejudicial, and we might exclude the public if there are issues in terms of you have a child testifying or something along those lines. Now, the defendant does not have an absolute right to attend his own trial. If the defendant is disruptive, that defendant may be removed and allowed to watch on closed circuit television. If we have to restrain the defendant, right, other restraint mechanisms may be too prejudicial. So for instance, if we decide that we need to shackle a defendant, what the judge will order is that both tables, the prosecution table and the defense table, have tablecloths over them that hide the fact that the defendant is in shackles, right? And the idea here is we don't want them thinking, oh, wow, the court already thinks he's dangerous enough. If we don't vote to convict this person, he's going back out on the streets and he's going to hurt someone, right? So we want to be as impartial as possible. That being said, juvenile records in juvenile trials, you generally cannot observe because they are sealed, right? So if you commit a crime when you're a juvenile, unless you're tried as an adult and you go down that realm, they are generally sealed. So meaning the public doesn't have access to the records, to the trials, public can't attend. And again, the idea behind here is they're kids, right? You don't want to overly hurt them, overly burden them. So next lecture we're going to look at is we will look at plea bargaining and sentencing. Thank you so much for watching. If you have any questions, as always, feel free to email me.